Hello Year 12s and welcome to this video on case management. As you watch this video, there are 4 things that you need to do. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause and rewind functions. Use the pause function if you need to stop this video so that you can take notes. Use the rewind function if you want to go back over any information contained in this video. The third thing that you need to do is have your vocabulary sheets open in front of you so that you can write into your vocabulary sheets the definitions of key terms and of any other words that you may be unfamiliar with. And the fourth thing that you need to do is have your summary books open in front of you. As we go through this video, I will give you some guidance as to what you should write in your summary books. This slide sets out our learning intentions for this video. As a result of watching this video and taking notes on it, you should be able to do 2 things. First, you should be able to analyse the role of the magistrate and judge in the case management of a civil dispute. And second, you should be able to evaluate the extent to which magistrates and judges achieve the principles of justice through their role in the case management of a civil dispute. Make sure that you write these learning intentions down in your Cornell notes. Magistrates and judges have been given significant powers to manage civil disputes. These powers are contained in the Civil Procedure Act 2010, which is a Victorian Act, and the Civil Procedure Rules, which are rules made under that Act. 2 of the most significant powers that magistrates and judges have to manage civil disputes are firstly, the power to order mediation of the civil dispute, and secondly, the power to give directions both before the hearing or trial of the civil dispute and during the hearing or trial of the civil dispute. The purpose of the Civil Procedure Act and of the powers that it gives to magistrates and judges is to facilitate the just, efficient, timely, and cost-effective resolution of civil disputes. Let's start off by looking at the power of a magistrate or judge to order mediation. Under the Civil Procedure Act and the Civil Procedure Rules, a magistrate or judge may make an order that a civil dispute is referred to mediation. When we say that a magistrate or judge orders that a civil dispute is referred to mediation, we mean that the magistrate or judge orders the parties to try to resolve their dispute with the assistance of a mediator. Mediation is a method of dispute resolution for civil disputes where an independent third party, called the mediator, helps the parties to resolve their dispute by making sure that both parties are given a reasonable opportunity to explain their side of the dispute to the other party. This also means giving the parties a reasonable opportunity to negotiate about how to resolve their dispute, including by the parties proposing and discussing possible solutions to the dispute. The role of the mediator is therefore to facilitate the parties having discussions with each other to see if they can agree on how to resolve their dispute. The mediator does not make suggestions about how the dispute can be resolved and does not decide the dispute for the parties. Instead, it is entirely up to the parties to see if they can agree how to resolve their dispute. Where a magistrate or judge orders a civil dispute to be referred to mediation, then the mediator can be either a court officer, such as an associate judge, or any other person who is agreed to by the parties. A magistrate or judge may refer a civil dispute to mediation at any stage of the proceedings, that is, either before or during the hearing where the case is in the magistrate's court, or before or during the trial where the case is in the county court or the trial division of the Supreme Court. Now, you'll remember that a very important theme that underlies the whole of Unit 3 is the principles of justice. Well, as set out in this table, the power to order mediation contributes to the achievement of two of the principles of justice, namely fairness and access. Make sure that you include this table in your summary books. First, the power to order mediation contributes to fairness. This is because in a mediation, each party, that is both the plaintiff and the defendant, are given a reasonable opportunity to explain their side of the dispute to the other party. And, as you know, one aspect of fairness is that a party has a reasonable opportunity to present their case. Second, the power to order mediation can contribute to the achievement of access. There are a few reasons for this. One reason is that because mediation is a much lower cost method of resolving a dispute than taking a case to court and undergoing a hearing in the magistrate's court or a trial in the county court or the trial division of the Supreme Court, more people can afford to use mediation to try to settle their disputes. In addition, if the parties can resolve their dispute by mediation, they will avoid the time and stress of a hearing or trial. Put another way, where a court exercises its power to refer a civil dispute to mediation, this can contribute to access because it means that the parties are able to enforce their rights without the cost, time, and stress of a hearing or trial. As you know, one aspect of access is that a party is able to enforce their rights. Finally, if the parties can settle their dispute by mediation, then the dispute will not take up the time and resources of the court, which means that the court is free to deal with other cases. This improves access to the legal system for these other cases. The second important power that magistrates and judges have to manage civil disputes is the power to give directions. A direction is an instruction given by the court that requires a party to do something or that states how a civil proceeding is to be conducted. Look down the left-hand side of your vocabulary sheets, find the term direction and write this definition in there. Under the Civil Procedure Act and Civil Procedure Rules, a magistrate or judge may make any order they consider appropriate at any stage of the proceeding. That is, either before or during the hearing, if the case is in the magistrate's court, or before or during the trial, if the case is in the county court or the trial division of the Supreme Court. The power to make directions enables the magistrate or judge to control the proceedings so as to minimize delays and so that the parties know what procedures they need to follow. As I've said, a magistrate or judge may exercise their power to give directions either before a hearing or trial or during a hearing or trial. Where the directions are given before a hearing or trial, they will be given at a directions hearing. A directions hearing is a pre-trial procedure at which a magistrate or judge gives instructions to the parties about time limits and the way the civil proceeding is to be conducted. Look down the left-hand side of your vocabulary sheets, find the term directions hearing and write this definition in there. On this slide, I've given you some examples of directions that may be given before a hearing or trial, that is, at a directions hearing. These examples include directions that set a timetable for pre-trial steps, such as the exchange of documents and other evidence that the parties will be relying on, and a direction requiring a party who wants to provide expert evidence to file the expert's report by a specified date, or to limit the expert evidence to specific issues. Directions may also be given by a magistrate during the hearing of a case in the magistrate's court or by a judge during a trial of the case in the county court or the trial division of the Supreme Court. Directions that may be given during a hearing or trial, including directions about the order in which evidence is to be given, a direction specifying the length of the hearing or trial, a direction limiting the cross-examination of witnesses to specific issues, a direction limiting the number of witnesses a party may call, a direction limiting the length of a party's submissions to the court, a direction limiting the number of documents that a party may provide in evidence, and a direction that certain evidence must be given orally and certain evidence must be given in writing. Now, as I've said before, an important theme that underlies the whole of Unit 3 is the principles of justice. Well, as set out in the table on this slide and the next slide, the power to give directions contributes to the achievement of two of the principles of justice, namely fairness and access. Make sure that you include this table in your summary books. First, the power to give directions contributes to the achievement of fairness because, by using the power to give directions to minimise delays, the magistrate or judge ensures that the case is proceeding as quickly as reasonably possible. This is important because parties are paying lawyers, and the longer the case drags on, the higher the party's legal costs will be. There's therefore a risk that a party will run out of the money needed to pay for a lawyer and will be unable to properly present their case because they will have to represent themselves. Put another way, the power to give directions reduces delays and therefore legal costs, and so makes it more likely that a party will be able to continue to pay for a lawyer to represent them, thus giving the party a reasonable opportunity to present their case. As you know, an important aspect of fairness is that a party must have a reasonable opportunity to present their case. So, for example, directions that set a timetable for pre-trial steps, such as the exchange of documents and other relevant evidence that the parties will be relying on, and directions that limit the number of witnesses that a party may call, are directions that are intended to ensure that the case proceeds as quickly as reasonably possible. In addition, directions help the parties to understand what they need to do to present their case, and this enables them to properly present their case. This contributes to fairness because it means that the parties will be presenting their case in a way that the magistrate or judge requires that case to be presented. So, for example, directions about the order in which evidence is to be given are directions that are intended to help the parties understand what they need to do to present their case. The second way in which the power to give directions contributes to the achievement of the principles of justice is through contributing to the achievement of access. By giving directions, the magistrate or judge enables each party to know what procedures the party needs to follow to pursue their case and enforce their rights. As you know, an important aspect of access is that a party is able to pursue their case and enforce their rights. So, for example, a direction that certain evidence must be given orally or in writing is intended to set out the procedures that a party must follow in presenting their case to the court. In addition, by using the power to give directions to minimise delays, the magistrate or judge is ensuring that the case is proceeding as quickly as reasonably possible. As I've explained, this reduces the risk that a party will run out of money for lawyers. A party needs a lawyer to advise them of their rights and to pursue their case and enforce their rights on behalf of the party. An important aspect of access is that a party understands their rights and is able to pursue their case and enforce their rights. So again, this is another way in which the power to give directions contributes to the achievement of access. Finally, by using the power to give directions to minimise delays, the magistrate or judge will be reducing the time that the case runs for. This in turn will free up the time and resources of the court to deal with other cases, which will improve access to the legal system for these other cases. So, for example, a direction that limits the cross-examination of witnesses to specific issues or that limits the length of a party's submissions to the court is intended to ensure that the case proceeds as quickly as reasonably possible, and this will benefit both the parties to the case and the parties to other cases who are waiting for their cases to be dealt with by the courts. Just a final word of warning. You need to remember that the power to give directions is limited to procedural matters, such as how much time the party has to make their arguments and whether evidence is to be given orally or in writing. So, for example, a magistrate or judge can't give directions to a party as to what arguments that party should make or what evidence that party must present. Well, that brings us to the end of this short video on case management. As a result of watching this video and taking notes on it, you should now be able to do two things. First, you should be able to analyse the role of the magistrate and judge in the case management of a civil dispute. And second, you should be able to evaluate the extent to which magistrates and judges achieve the principles of justice through their role in the case management of a civil dispute. Thank you for your attention.